Hello, everybody. It's attorney Laura Sterling. Welcome to my live show. Whether you're joining me on Facebook or you're joining me on YouTube, however you watch me, welcome. And as you can see by my backdrop, I've gone away from the gray and now I'm in the Christmas spirit because can you believe it? Count them, 6 more days till Christmas. I'm hoping you're more prepared than I am because I am not prepared. I was just telling my staff how last night I was trying to Christmas shop online and this was me. It was too much. I had to go to bed. So it looks like I'm going to be physically walking myself to a mall, which I haven't been in a mall in a while. So I still need to get ready for Christmas. I still have things that I need to get and things that I need to do. So hopefully I can do that before the holiday hits. I hope that all of you are enjoying your holidays. I know it's chilly down here in Florida. I mean, I know chilly to you and chilly to me are probably way different things, but it is a little chilly. That's why I have my coat on, my turtleneck. It's a little chilly, but it's supposed to warm up by the weekend. So that's a good thing. So I hope you all are enjoying this holiday season, that you plan on getting together with family and friends and celebrating. Hi, Christopher. How are you? Oh, thank you. Thank you. Happy holidays to you as well. Whatever you may be celebrating, Hanukkah, Christmas, whatever it may be, although I believe Hanukkah is finished now, but that you're enjoying it and that you're enjoying time with family. Hopefully I'm not going to go the whole hour today. I know that y'all are probably busy if you're like me, trying to get last minute Christmas shopping, grocery shopping. I was at the grocery store last night late and they were missing a few things that I needed. But I'm hoping to get them either today or sometime this week. So hopefully they restock. I'd asked the lady, "Have you been busy?" And she said, "Well, we've been steady." So I guess steady's busy. But, I still need to get things. So I was going to go away, it looked like, but I think I've changed my mind. I'm not really sure. I haven't made a decision yet. So um, the fortunate or unfortunate thing is when I travel, I have my two puppies now. So if I do travel, I have to figure out what I'm going to do with them. So but anyway, it's at least as long as I'm with my family, my husband and son, that's all that matters. I wish I was with my parents and my siblings, but can't have everything. As you know, they live in Minnesota. I live down here in Florida, so it's not a hop, skip, and a jump to get up there. And you never know with the weather what could happen. I guess there is a little snow on the ground and it is cold. So as you know, this is my live show. So please, 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 if you have any questions whatsoever in regards to what we're going to be talking about today, please feel free to just type it in the chat. My staff will give it to me. I don't want you to be like, well, I don't want to disturb her. I don't want to ask the question now. Please do, because I enjoy the questions because sometimes the questions that you ask kind of put me off on a different path that maybe, oh my gosh, I should have covered that, but I forget to cover it. I get into the middle of what I'm doing and maybe I skip over it, or maybe there's something else I should have put in there. So I do appreciate your questions, and lately I've been getting some really good questions. So I'm quite impressed with my crowd that's watching me, that you guys seem to have a lot of knowledge about the law and you just want some clarification. Understand that the law is not really what you see on TV, like a Law and Order. I one time had a case and it was an easy, simple, divorce. We went in, got it finalized. Both parties had agreed. And we walk out. My client goes, "Well, what happened? I wanted the objection." You're not getting that. Okay. You should be happy that it was, agreed upon and everything was calm and everything was cool. So know that that's not always how the law works. So I'm here hopefully to maybe shed a little light on that or answer any questions you may have in regards to that, because I think that's where we get most of our knowledge from, is television or radio or what we read on the internet. I was going to say read in the newspaper, but not many people get newspapers anymore. So it's mostly on the internet. I know I get alerts on my phone from the local paper here in Orlando, the Orlando Sentinel, and I do appreciate that because does provide a lot of information. Anyway, so please introduce yourself, say hello, ask me any questions. My staff will drop it for me to read it, to answer it, and hopefully I can answer those questions for you. Please know I always do this disclaimer. I'm licensed in the state of Florida. That is it. So if you live in another state, if you live in California, New York, New Jersey, Texas, whatever, I can't answer those specific questions. So those would be best answered by an attorney in your state. I can answer here in Florida. Anywhere in Florida. You live in Tallahassee, I can answer it. You live in Quincy. Believe me, I have gotten to know some really small towns that I didn't realize were here in Florida. But if you're in Tallahassee, Quincy, Cocoa Beach, Miami-Dade, Fort Myers, I can answer it as long as it's within the borders of Florida. So please take a deep breath, relax. If you're here in Florida or someplace else that's cold, get your blankie, roll up in it, get your little popcorn or whatever snack you want, get your little soda or your water, maybe a pad or a pen if you want to write down some notes that I'm going to give you. But please know we are going to record this. It's going to be on YouTube and Facebook for as long as it will be, and you can always refer back to it if you have questions. So anyway, so sit back, relax. Let's get started. Now, as you know, I always say the end of the year, November, December, is what I say for what do I want to say, my criminal review. And not that that's necessarily something I want to talk about around the holidays, but that's when it seems to come out the most, right? We're celebrating. We're going to family for Thanksgiving. We're watching football. Maybe we're drinking. Maybe we argue about the football. Now it's the NBA. We argue about the NBA. Things happen, you know, drunk driving, battery, all that kind of stuff. So we want to make sure that we're prepared. And so, okay, what are the definitions or what are the differences between certain crimes? As you know, I've been doing these videos all month and kind of talking to you a little bit about the differences. And it's funny that we've had some newsworthy items come up in reference to some of these issues that I'm going to talk about today. For example, let's start with a battery. A battery versus battery domestic violence. That's what we call it here in the state of Florida. It may be different in different states. For example, I don't know if you know Jonathan Majors. I knew nothing about him. I'm not a Marvel Comics person. I don't follow that too much. But apparently he was an actor in Ant-Man. So he was just found guilty. I'm not sure what state. I'm thinking it's California, of a misdemeanor assault, which is the same definition as it is here in Florida for battery. So battery here in the state of Florida is the intentional touch or strike of another individual without their permission. So what does that mean? Does that mean I have to haul off and hit them, or I got to break a bone for that battery to take effect? No. Simply somebody coming up to me and tapping me on the shoulder could be a battery. If it was uninvited, if I did not consent to it, that's all it has to be. There doesn't have to be an injury. Now there is a different battery, and I'll get to that there has to be some type of injury. But for a simple battery here in the state of Florida, simply has to be a touch that was intentional and uninvited and not given permission by that person. So let's kind of talk about battery for a moment, because as you all know, and in my video, I talked about the Warriors player, Draymond Green. I think that's how you say his first name. And excuse me if I'm pronouncing it incorrectly. I don't know if you watched the video, but he was playing and they were playing against the Suns, and he struck the Suns player during the game. Now, so the elements of that would be if there were criminal charges brought up. He's suspended indefinitely by the NBA. That's the National Basketball Association. They're doing their own thing. But if criminal charges were brought up against him, the state attorney would have to prove, one, that there was an intent to strike. Now, looking at the video and having my criminal defense mind, there was a lot of flailing, a lot of moving around. Of course, all my friends that I talk about, they're like, oh, no, he had an intent there. He's got a history. Apparently, he's had a lot of these issues. I'm just looking at the straight video because that's what I would look at as a criminal defense attorney. I wouldn't look at what he did last week or what he did 3 weeks ago or what he did a month ago or what he did last year. I'm looking at the video that's presented to me. And so, can the state prove number one, that it was an intentional touch or strike? Was it on another person? Yes, he did touch that other person. And number three, was it consented? And obviously, it wasn't consented. So that's where the state would have to say, okay, in looking at this video, can I prove intent? That there was an intentional strike, that he had the intent to strike that person? Or was it in the spirit of the game and just trying to get the ball and this and that? We shall see. I don't think there's been any criminal charges, but we'll have to see what comes down the pike. So that's a simple battery. Now we move into battery domestic violence. Battery domestic violence here in the state of Florida is what's his name, Jonathan Majors, what he was charged with. That he was charged with it, but they ended up dropping or not ruling on those charges and finding him not guilty, but just finding him on the assault. What happened there was it was an ex-girlfriend. So there was that relationship there, that intimate relationship. So battery domestic violence means, at least here in the state of Florida, it was a family member or it was a friend or somebody you shared a relationship with or somebody you shared a house with or something like that, where there was that relationship, that little extra kind of umph to it, not just some stranger. And I've had it where I've been a criminal defense attorney for a stranger fight where it was just a battery, not a battery. We call it battery DV, battery domestic violence. So there has to be that familiar aspect there. And so with Jonathan Majors, it was at the time a girlfriend, now a former girlfriend. And so that's where the domestic violence came in. And he only got charged with a misdemeanor. The more severe charges that were felonies were he was found not guilty. And what ended up happening was, I guess she had some kind of injuries. And so that could have bumped it up to something more severe. Now, here in the state of Florida, if you have a prior charge of a battery, that could be enhanced, meaning I pled out or I was found guilty of a battery, and then all of a sudden now I have a second battery or a third battery. That in itself could be a third degree felony, which, as y'all know, could be a maximum of 5 years in jail. So that's just based on one prior conviction. They can up it to a felony, and then you're looking at potentially 5 years in prison here in the state of Florida. Hey, Isabella, how are you? What your question is, what are the typical penalties for a battery conviction in Florida? I'm curious about the legal consequences. Well, when you say a simple battery, a misdemeanor battery, and a battery DV or battery domestic violence, again, misdemeanor, they're both M1s, we call them, first degree misdemeanors. So the maximum penalty is 1 year in jail and a $1,000 fine. Now, what I'm just introducing is the felony, the third degree felony. That's a maximum of 5 years in prison and a $5,000 fine. So if you have a prior misdemeanor battery conviction and now you get a second one, that could bump you up to a felony or a third one. Now we have felony battery, which that was what Jonathan could have been could have been found guilty of. And that's what, again, an intentional touch or strike of another person without their consent. But the extra element is it causes great bodily harm, permanent disability, or permanent disfigurement. Great bodily harm, maybe a bone is broken, maybe there's bruising, black eye, anything like that that causes that disfigurement or leaves a mark or anything like that, that is severe enough that it can cause a mark. Now, just having a red mark, maybe there's a slap, that doesn't necessarily bring it up to a felony. But if there's broken bones or fat lips or blood from the eye or something. I mean, I've seen it all. So that could, you could be charged with felony battery. And again, that's a third degree felony punishable by up to 5 years in prison. So there's also a felony battery under that same statute where there's a felony battery, meaning great bodily harm or permanent disfigurement or disability. There is domestic violence is under there as well. Domestic battery by strangulation. So, Isabella, I hope I answered your question. I'm going to go more into something kind of off of that. But if you have more questions, please let me know. But fabulous question. Domestic battery by strangulation is also a felony. And what that is, and I've had this too, where there's a strangulation, there's a cutting off. Like even when I do this, my turtleneck sometimes feels like strangulation. But when you put your hands up and it kind of blocks that ability to breathe, that's strangulation. And that's a felony. So it's somebody that is in a domestic situation, boyfriend, girlfriend, friends, mom, son, whatever it may be, and that strangulation, which is cuts off that normal breathing or that normal circulation, that is domestic battery by strangulation, and that's a felony as well. Now the person does not, and I repeat, does not have to lose consciousness. It's not like, oh, it can only be battery by strangulation if they lose consciousness. No, you can cut off that circulation where they can't breathe for a short amount of time. Maybe they don't pass out, but they have it. Now, I've seen pictures where there's been red marks on the neck from the strangulation, and that shows the depth of the strangulation, that it leaves marks behind, and finger marks and all of that kind of stuff. So that is, domestic battery by strangulation, knowing that it's the domestic violence. Anytime you see domestic battery, domestic violence, or anything, it's either by a family member or a household member or a domestic or dating relationship. And so that would be, again, third degree felony, felony battery. If you've had more than one conviction or plea agreement, you entered into a plea, or battery by strangulation, or felony battery, meaning some kind of great bodily harm, or permanent disability or permanent disfigurement. So that's a battery versus battery domestic violence. And it's funny that we just had some of those in the news. So, hey, Bob, how are you? You have a misdemeanor battery charge / striking. And she was the one that threw the first punch twice, one in, I'm assuming your right eye, and one in your groin, I'm thinking groin area, and scraped my hand with nails. She claims it's self-defense. Wondering, does a case like that go on, or would this be dismissed as to who strike who first? Well, you're saying you have a charge. I don't know what the status is of it at this point. And I'm not sure if you're in Florida. Let's assume you're in Florida. So what I would do is I would claim if the case is that she threw the first punch, you were trying to defend yourself, not sure what you did to defend yourself and why they would have arrested you or charged you. But if you're trying to defend yourself, then you can always do the self-defense defense of saying, hey, he was defending himself based on the evidence. I've been able to get things dismissed just saying that to the state attorney, hey, come on. A lot of times at the battery domestic violence, you got the woman, you got the man. If there's marks somewhere, they're going to take. I'm surprised they didn't take the both of you if you both had marks on you. But, can't comment on that. But hopefully it would be looking at the evidence, addressing it and saying, hey, they both had marks. What's going on here? Why are you only charging him and not her? Now, they may charge her down the road, but they need to look at it, investigate it, and see what's going on. But a very good question in regards to that, because it's hard sometimes. I think the police show up and they just want to separate you. They want to separate you. Sometimes they tell you, hey, is there someplace you can go tonight? Or is there someplace you can go tonight? Or they say, okay, I'm taking you in. In Florida, when they arrest you on a battery domestic violence, I don't know if you were arrested or not, Bob, but if you were arrested, they're not going to give you a bond. You're going to have to sit there for 24 hours because what they want to happen is everybody to calm down. And they're hoping that that 24 hours. Now, one time I did get a call from one of my clients in the middle of the night. I can't remember how she had my cell phone, but I do give my cell phone out at times. But I got a collect call from the jail from my client who had been arrested the night before on a battery domestic violence. And she wanted to get out, but you can't get out. They're not going to let you out until first appearance because, again, they want you to calm down. They want, the fire. But of course, you are let out, either ROR on your own cognizant with no bond or a bond, but you have a no contact order. You cannot contact the other person, and you don't want to contact the other person because you could be right back in jail and you don't want that. Okay, I'm sorry to put up another one. So I hope that answers your question, Bob. I mean, I don't know if you have an attorney, if you're here in Florida, we'd be happy to talk to you, but to see what the facts are. I always have to see what the state has because the state's job is to prove your guilt. It's not your job to prove your innocence, but I want to see what they have. What can we attack? And go from there. So if it's a self-defense, I would assume that you had marks as she was striking you, like you said, as she struck you in the face, and there were scratches on you. You should have marks. I don't know what you did to defend yourself, but that would be interesting to see. So very good question, Bob. I'm sorry you're going through that. I hope if you're not here in Florida that somebody can help you out. Some attorney wherever you are can help you out, so that you can kind of get through this time. It's not a fun time to have to go through something like that. So I'm sorry you're going through that. So anyway, so that's battery versus battery domestic violence. So moving on to the next one is no valid driver's license versus a suspended driver's license. Now, I got to tell you a funny story. Here in the state of Florida, a no valid driver's license, you cannot be a habitual traffic offender under a no valid driver's license, which means a no valid driver's license will always be a misdemeanor. Always, 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 always. It's always going to be a second degree misdemeanor, meaning it's punishable by up to 60 days in jail and a $500 fine. It always, always will be. In fact, one time I had a client, he had 9 no valid driver's license, 9 of them. Now, you can get jail. Like I said, 60 days in jail. So the state, obviously, they wanted 60 days in jail. So I'm like, wait a minute. Come on. Can you give me? I think they wouldn't come off the 60 days. So I said, okay, I'm going to go in front of the judge. I'm going to see what the judge says. So my case gets called. I go, Your Honor, can we approach? Because you can always approach as attorneys to talk to the judge to say, hey, this is what's going on. See what the judge will do. So we approached and I go to the judge. Listen. Okay. I understand this is my client's 9th no valid driver's license. The state wants to give him 60 days. I am coming to you, he has a mother. He has an elderly mother and I don't remember where she was. Let's say Mexico. He has an elderly mother in Mexico. He sends money to her. And if he isn't working and he's in jail, he won't be able to send money to his elderly mother in Mexico. And the judge does this. And this is me. That's all I have, Your Honor. That's all I had. I don't know what else to say. He's got 9 no valid driver's license. He keeps driving. Well, the judge gave me a break, gave 30 days, get 5 days for every credit. So he would have served, and I think he served a couple days already. So I told him, hey, you'll be out in 20. You'll be fine. So he did have to serve those 20 days. But, driving anywhere in the United States, not just Florida, is against the law. You have to have a driver's license. I can't tell you how many people I've spoken to that want to argue with me about in the Constitution how it says that we can travel. Yes, you can travel. Yes, you can. By foot, by bicycle, by bus, by somebody else driving you, by airplane, by any way possible. But to drive on the roads here in Florida or in any state, you have to have a driver's license. You have to have a driver's license. No matter what, you have to have one. And I feel bad for some of my clients because they're like, they're scared and they don't want to go to jail and they don't want to keep going to court. And they're like, can you ask the judge if I can get a driver's license? And, it's not really up to the judge. You have to somehow do what you need to do to get a driver's license, whatever that may be. So No valid driver's license. I had somebody that had 9 of them. You're probably going to be looking at jail time at that point. Well, probably even before that. I had one judge that after your second one, she was putting you in jail, which was sad. But either way, so that's a no valid driver's license, meaning you never had a driver's license. You never, ever, ever had one, and you were caught driving without one. So now a suspended license is a whole different ball game here in the state of Florida. A suspended mean you had one at one time and it was suspended or revoked for whatever reason. Whatever reason, there's a barrage of reasons that your license could be suspended or revoked. It could be too many DUI convictions. It could be a drug conviction. It could be you're not paying your child support. Um, it could be a barrage of things that could happen that your license is suspended. Now, the first time you get driving on a suspended license, again, that's a second-degree misdemeanor. So that's you could face up to 60 days in jail and a $500 fine. So, but however, after that, it could go your second conviction or your second plea, your second whatever it may be, being caught with a suspended driver's license, it moves up to a first degree misdemeanor. Then you're looking at 1 year in jail and a $1,000 fine. Now, a third offense of driving on a suspended license in the state of Florida could result in felony charges. That's really up to the state attorney whether or not they're going to what we call habitualize you, turn you into a habitual traffic offender. And now you're looking at a misdemeanor. I have a client now that he's had one driving on a suspended license prior to me. Now he's working on a second. And I'm like, you have to be careful because the state can habitualize you. And then you're looking at a felony. Hey, Laura. Oh, love your name. Laura, what should someone do if they're pulled over and they're driving on a suspended license in Florida? Are there any immediate steps to follow? I mean, whoever pulls you over here in Florida, whether it's a Florida Highway Patrol, the local police, the sheriff, or whatever, they immediately can look at your drive. They can look up your driver's license either by the plate on the car, if it's registered in your name, Laura, and they see that you don't have a valid license. Maybe, like you said, it's suspended. They can see that, or they approach you. I don't get some kind of ID or something. They can check it. They can check it. So they already know when they're coming up to your car that you have a suspended license. And so what you really need to do, as I always say, is just keep it quiet. Just keep it quiet. Just answer the questions. What is your name? That's pretty much about it. After that, you just say, I need to speak to an attorney. You just give them what they need. Don't fuss with them. Don't fight with them. Just don't talk. I can't tell you how many clients I have that come to me, not just on a suspended license, Laura, but on different issues, drug charges, anything. And they have just, I call it vomited to the police. They what we always believe that, well, maybe if I just tell my side of the story, they won't do anything. No, they will. If you're on a suspended license, yep, they can arrest you, not that you'll stay in jail because you're entitled to a bond, of course, or they can just give you a ticket with a notice to appear. But there's no point in you sitting there trying to talk, trying to say things, trying to do all that because they're going to do what they have to do. So keep your mouth quiet. It'll be easier for us to work your case if there's not oh, people want to, oh, I didn't do it, or I did this and I did that. Just keep it quiet and just listen, do what you need to do to be able to either, they're not going to let you drive off. I'm telling you that right now. You're going to have to call somebody to come pick you up. Or if they arrest you, you're going to get out. That's not a problem. You get a bond. You need to call somebody to come and get you and just do what you need to do to just get out and then contact an attorney. That's what I would recommend you do, Laura. So very good question, though. I appreciate that question because I think that's a lot. I think people are worried about what they should do when they get stopped. And I always tell people, I get the police reports and I see what was said. And I always tell them, and I don't want to make my clients feel bad for having said something. I try to be as, how do I want to say this, as diplomatic as possible and saying, in the future, if you get stopped, don't talk. Don't talk. Just Do what you need to do. I understand, why you spoke. I understand you're scared, you're nervous. And when we're scared and nervous, we tend to talk really fast or we tend to talk a lot and we want to get out of it. And it doesn't work. It doesn't matter because they're not there for you. They're there. Okay, you've broken the law. So they're not your friend. They're there to enforce the law. So you telling them things is not going to help you. So just do what you need to do and then get on with it and then contact an attorney. Excellent question, Laura. Thank you for asking that. So, you're welcome. You're welcome, Laura. Okay, so as we talked about, if you get a third offense, the state attorney could make you a habitual traffic offender, and then you're looking at 5 years, a maximum. Now, I say a maximum. I don't mean you're automatically getting 5 years and see you in 5 years. No, I mean there's negotiating. There's different defenses, all that kind of stuff. That you're not. These are maximum penalties. I always tell my clients, this is your maximum exposure. If you were to go to trial and you were found guilty, this is the maximum that the judge could give you. Not to say the judge will give you that, but you never know. But this is the offer, these are the pleas, all of that kind of stuff. Now, of course, the third offense, if you have three offenses within 5 years, the Department of Highway Safety, the DMV here in Florida, will categorize you as a habitual traffic offender. And that could result in your driver's license getting revoked, meaning taken away from you. What the DMV and what the state of Florida and what the United States looks at is a driver's license is not a right. It's not a constitutional right to have a driver's license. It's a privilege. So when you get that privilege, these are the rules that you have to follow. These are the laws that you have to follow. And so that's what they look at as driver's license. So the DMV says, "Hey, you're not getting it. We're going to revoke it." And then anybody categorized as a habitual traffic offender cannot get what we call a hardship license. When you have that suspended license, maybe applying to the Department of Motor Vehicle to get a hardship license, meaning I have a medical condition. Maybe I go to dialysis 3 times a week, and the only way to get there is for me to drive. And I need that driver's license. But you have to go through this whole, believe me, it is not easy to do. I've done it a couple times and it's difficult, very, very difficult. So, but that's what a hardship license is. So if you're a habitual traffic offender, after you've had 3 convictions of a suspended license in 5 years, the DMV is not going to be very happy with you. Now, again, I said the reasons that your license could be suspended. Again, child support, DUI. I have one right now. He didn't pay. He had a bunch of traffic tickets. He didn't pay them. What happens is a court can do, here in Florida, can do what we call a D6, meaning suspend your license until you pay. So I brought my client in front of the judge on the suspended license, and she was fabulous. I just want to say out, I'm not going to name any names, even though I'm saying she's fabulous, but she removed the D6. So he was able to go to the clerk and start a payment plan. And he's been paying on it. And that D6 was removed. So he's able to reinstate his driver's license. As long as he continues to pay on that payment plan. If he misses a payment, boop, the D6 is back in place. His license is suspended. So I cannot tell you how much I sat in front of him, excuse me, and said, it is very important that you pay on this payment plan. Otherwise, your license will be suspended again. So it gives him the option of a payment plan, which is good because it gives him time. Maybe he couldn't pay everything all at once. Maybe it was too much for him. He fell on hard times, whatever. But that the judge offered him this payment plan. So anyway, so that is a no valid driver's license versus a suspended. Remember that the no valid driver's license, you never had one. You never got one. Never, ever, ever. And you're caught driving. The suspended is you had one, but it's suspended. Either it expired, so it's no longer valid, or you weren't paying child support, you have unpaid fines, whatever it may be, that license is suspended. And that can pose you problems. Driving on a suspended license can pose a lot of problems. And like Laura said, if you get stopped and you know that's going on, just do what you need to do. Chances are you will get arrested, but you will get a bond. You will just, unlike the battery DV, you'll be able to just process yourself out. The battery DV, they want you to sit. I used to say it was like a drunk tank, remember that old saying where you get arrested on a DUI, they make you sit there for so many hours so you can dry out. Well, think of it like a battery domestic violence is kind of the same thing. It's like a drunk tank, but for battery domestic violence. They want you to sit there, cool it down, take a breath, and then you go in front of the judge, get a bond, and you're out. So, but again, a no contact order. Now we move on. You guys have great questions, by the way. I just want to point that out. Now we move on to our final little ditty, which is petty versus grand theft. Now, petty, the way it's spelled here in the state of Florida, looks like one of those little um I don't know, little like candies or something from Paris, right? Or little Danishes or something. Think of it that way. Petty, little, like little petty. Petty theft occurs when a person steals property from another person or business, obviously without their consent, when the value of the property is less than $750. So if it's 749 and below, it is petty theft. It is small. It's petty theft. Anything 751 and above is grand theft. So think of it that way. Grand is big. Grand theft, petty is a little beep, 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 little thing under $750. The theft doesn't have to occur in a store. I'm telling you, I've watched again many videos. I really have watched a lot of videos over my time of being an attorney and seen what not to do. So I had a client that I think it was JC Penney. I don't remember. Are there any JC Penneys anymore? But that shows how old I am. And the camera's following. You see the camera moving. And, they're touching clothes and they have a bag over the shoulder and they're touching. All of a sudden, you pick up a big shirt, put that shirt over the shoulder like they're going to go try it on, right? They're going to go to the dressing room. Sometimes I get so many in my hand, I put it over my arm because my hand is starting to hurt or I'm getting marks on my hand from holding it. So I put it over my arm. Well, this person put it over their shoulder, so it covered their arm. Then they're walking around some more, touching stuff like we do. We don't even think about it. All of a sudden, you see this little movement, right? And so then that little movement, and again, the camera's watching and come and all of a sudden takes the thing off the arm, the shirt or whatever, puts it away, and then, starts heading towards the exit. You see an employee race right after. So anyway, whatever, I think it was a petty theft because it was under $750, but they watch you. They watch you in those stores. You think you're just minding your own business. You're not. Big brother's watching you. Another thing that can happen is those pesky self-checkouts. We all know what they are. They're at Walmart. They're coming here in Florida in Publix. I am so careful. I rarely choose the self-checkout unless there's nobody out, there's no humans to take me, or the line is all the way down. Then I'll do the self. But I make sure I separate everything, that I make sure I do one thing, it gets on there, and then I put it there. Okay, do another beep, beep. Okay, is it on there? Yep. Okay, put it there. Because I've seen so many videos where things are being forgotten and slipped through and slipped that. And I'm telling you, there are cameras everywhere. There's cameras above you. There's cameras in front of you. There's cameras to the side. There's cameras below you. And I've had many clients get taken into custody by the theft control of that store and been watching videos where, whether by accident or whether intentional, they're saying it's intentional. You're saying it's accidental. Watching the video, it's really watching the video. And I do have my clients watch the video. But anyway, so petty theft is anything under $750. So the prosecution, what they need to do to prove this petty theft is that you, the individual, they say defendant, but I don't like to use the word defendant. I use my client. I like that term. Defendant is so, out there. It's like you're automatically guilty. No, I don't look at it that way. But that the individual knowingly and unlawfully obtained or used the property of the alleged victim or attempted to take it, and they did it with intent to permanently or temporarily deprive that person of the right to that property. And that, so you're taking that. So it doesn't have to be necessarily from a store. It can be from, your friend's house or your neighbor's house, and you take something from your neighbor and they didn't give you permission and your intent was to keep it. And so that's what we look at when we describe theft here in the state of Florida. So there has to be the intent. Now, you're at your neighbor's house and you pick up your coat to leave and you get home and you realize that you accidentally took your neighbor's mittens that were underneath your coat. That's not theft. I mean, obviously, then you would just go, hey, neighbor, I took your mittens by mistake. I apologize. So, anyway, let me go over with you about there are different degrees of petty theft. There's first degree petty theft, which is punishable by, again, that's a first degree misdemeanor, 1 year in jail and $1,000 fine. That's when the property value at issue is more than $100, but less than $750. So that could be a barrage of things. Let me think. What would be that? Maybe an iPad, Apple headphones, something like that. I think most iPads are under 750. So, if there's one more than 750, I tell you, I hope it does everything for you. You just have to look at it and it's reading your mind. But so that's anything more than $100, but less than $750. Now, second degree petty theft, again, is a second degree misdemeanor, punishable by a maximum of up to 60 days in jail and a $500 fine. So that's where the property is valued at less than $100. What would that be? That would be like a pack of gum or this lip gloss or what's another thing? I don't think I have anything on my desk that I could really point to. But that's something that's less than $100. So even a pack of gum or Tic Tacs or candy or whatever, that would be a second degree petty theft. Now, a felony petty theft, which can be charged as a third degree felony, again, looking at 5 years in prison and a $5,000 fine, is where the defendant has been convicted of 2 or more times of any theft offense. So if you've been charged with 2 petty thefts of the first degree, they can bump it up to a felony petty theft. And then you're looking at an we call it F3. You're looking at 5 years in prison, maximum exposure. So that's what happens when it continually happens and continually happens. They want to make sure that they punish you, for lack of a better word. Now, grand theft is defined, again, the same elements, knowingly and unlawfully obtaining property of another and the intent to deprive them of the ownership or the use of it. But it has to be $750 or more. So anything above that. So what would that be? A car, right? Grand Theft Auto, right? A car. It could be, if you have a really nice computer that's over $750, could be that. It could be a barrage of things that are over. A coat that's maybe cost you more than, a woman was telling me this morning how she had purchased this nice, beautiful goose down parka back when she lived up north, and on sale it was $500 and not on sale it was $1,000. You took that? That's grand theft here in the state of Florida. So we have levels of grand theft. So we do have grand theft of the third degree. Again, 5 years in prison. That has to be something that's valued more than 750, but less than 20,000. I know this is a lot of math, and I am no way, shape, or form in any way trying to throw numbers out there to confuse you. But this is what the state does here in Florida as far as saying, okay, what level are we looking at? What is the punishment? What do we need to categorize it at when we file our information or when we go forward filing charges? So a third degree grand theft is punishable by 5 years, maximum of 5 years in prison, is something that's valued at $750, the least, all the way up to $20,000. So we have a second degree then. We move on to the second degree. Let me take a drink for a second because now I'm starting to get dry mouth. Second degree is maximum penalty of 15 years in prison. That's the maximum exposure. And what that is, the property is valued at $20,001, but less than 100,000. So the minimum is $20,001. The maximum is 100,000. So again, that's a vehicle. What else could it be? Jewelry, potentially somewhere. Really expensive jewelry, but it could be jewelry. So, or I'm trying to think, oh, a boat too, a boat, a motorcycle, anything like that, that is worth more than 20,000, but less than 100,000. Now, of course, we have the first degree, which is punishable by up to 30 years, maximum exposure, 30 years in prison, is if the property that is stolen is valued at more than $100,001. If it's worth more than that, then you're looking at a maximum exposure of 30 years. So let's think what could a really expensive car, right? Like a Lamborghini. I'm not a big car person, so I'm not really sure. But Lamborghinis, I guess they're over 100,000. But anything over $100,001 is considered that grand theft, and you're looking at 30 potential of 30 years in prison. So those are kind of the how we categorize our thefts here in the state of Florida. I don't know if I've had, oh, yes, I did have one grand theft, but I think it was grand theft of the third degree. So my client was looking at a maximum of 5 years, but I ended up getting, and we do have offered here in the state of Florida, and you really checking with your own state. We have something called pretrial diversion. I mean, it can go by a barrage of different names here in the state of Florida, but pretrial diversion is one of them, or pretrial intervention. And what it is it's if it's your first offense, and it's really up to the state attorney if they're willing to offer it, is if it's your first offense, you've never been convicted before, you've never had it, you have no criminal record, they can offer that pretrial diversion. And what it does is it allows you to do certain things. You're more or less put on probation, and you've got to complete certain things. Like in theft, you would probably do an impulse control class, maybe a mental health evaluation and treat, all of that, which you would have to do anyway. Probably if you accepted a plea offer and pled to probation, you'd have to do it anyway. But at the end, if you've done it all successfully, that pretrial diversion, you've completed your probation with no new law violations, you've completed the or the impulse control class, you've gotten the mental health evaluation and treat, all of that, and you've done it all successfully, they will drop the charges. We call it a a null prosecution, meaning no prosecution. It's Latin, no prosecution. They'll drop it, and you don't have that conviction. Now, you still have the arrest, and you may want to address with an attorney about how to get that off your record. I have clients ask me all the time, how can I clean my record? I always think of Windex, but meaning sealing or expunging your record. So if I go and I Google you, it doesn't come up. And employers, except for the federal government, obviously they can see it. But if you're going to get a job like at Walmart or something, it doesn't pop up as that arrest, because it still will show as an arrest, but they'll null process or dismiss it if you've completed that pretrial diversion. And I always encourage my clients, anytime I get that offer, I can get that offer from the state. I always encourage my clients. In fact, I call my client and say, you need to take this. And I usually don't do that. I usually allow my clients say, these are your options, going to trial or, accepting the plea after we've done everything that we need to do, maybe motions and all that kind of stuff. When it gets down to it, these are your two options. So if pretrial diversion is one of them, I'm like, take it, take it, take it, take it, take it, because that's your one bite at the apple to kind of clean your record and say, I had a young guy one time, very young, just out of teenage, and it was like the state attorney was like, listen, I don't want him to be a convicted felon. I want to offer this pretrial diversion for him, and he completed it successfully and got it dismissed, and fabulous. I was very proud. So I'm very happy when that happens with my clients, and I really encourage that. And we check up on them too to make sure, okay, you're doing what you need to do. Okay, you're doing what you need to do. Okay, remember you need to do this, because I really want that to be dismissed. So again, let's kind of take a breath. So let's kind of review. So we talked about battery, the simple battery, where we talk about the intentional touch or strike of another person without their permission. Again, it can just be the beep, beep. Hey, ma'am, beep, beep. I got to tell you, one time I was at a football game, not telling you who was playing, but one of the other fans came by and smacked me on the top of the head. Like, I couldn't believe it. Like, really? What made you think that you could do an intentional strike on me? I mean, I wasn't injured, obviously, and you don't have to be injured. That was an intentional strike of a person without their consent. Like, really? But whatever. I just, let it fly. But the intentional strike of another person without their consent. Battery, domestic violence, again, is the same thing, intentional strike without their consent, but we're adding that familial, that family relationship or that domestic relationship, dating relationship, whatever it may be. Next, we have the no valid driver's license. Never had one, never got one, never, ever, ever. My grandmother was like that. She never had a driver's license. My grandfather had to drive her around. She never, ever, ever got one. But no valid driver's license, never had one. Suspended, you had one, but it's suspended, either expired, or you didn't pay your child support, you didn't pay your fines, your DUI convictions, whatever it may be, you have that suspended driver's license. Then we go into the theft. We have petty theft. Remember petty, beep, 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 petty theft, small, 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 anything under $750. Grand theft, think of it, grandiose. Anything $750,000, 750,000 really, $751 and above. Infinity. That's grand. That's grand theft. So think of it grand, petite, grand. That's how I always like to remember it way back in the day when I was in law school. I know it's hard to believe that those cobwebs are still there. But anyway, that's what we talked about today. I hope this helped you. I appreciate all of your questions. They were excellent questions. I don't know if it's me educating you, but you people seem to be very educated on what's going on, and your questions are excellent. They help me kind of broaden it out because I always say, your question, there may be another question just like it. And so another person may have the same question, but they're kind of shy or they're afraid to ask it. So your questions are fabulous. Once again, from us here at Tria and Sterling, I want to wish you all a happy holiday. I hope that your holidays are great. I hope that you spend them with your family, with your friends, with your loved ones, whoever it may be, and that you have a safe holiday. And I won't even see you until after the new year. So I hope your new year goes great. I don't make resolutions, I make visions. That's what I do. So try to think of what your vision is going to be for 2024. I know my vision for you is that I see you in 2024 and that I help as many as you as I can. So have a great holiday, and I'll see you in 2024.